Good afternoon, everyone. I'm Judge Corey Amanda Cawthon. We're here for the afternoon session of First Appearance Court. I will begin by going through our first appearance docket for this afternoon session, and then we will go to our hearing docket following that. Just a reminder to everyone that everything that we say is being recorded and can be used against you at a later date, and so I encourage you to speak with your attorneys before speaking on the record this afternoon. Before I get started, I just want to double check with Mr. Romero over at the Main Jail. Is there anyone that needs to be called out of turn at Main?
No, Judge.
All right, thank you. I have reset to the PM docket from this morning. Anthony Kyra, is he present?
He is here, Judge.
Okay.
Come on up, Mr. Farrell.
Good afternoon, Mr. Kyra. You're before the court this afternoon on two charges. Count one is for possession with intent to sell, manufacture, or deliver cocaine. Two is a felony probation violation that has a no bond hold. I find probable cause, and I'll hear from the parties if they wish to be heard on count one.
Judge, I did explain to Mr. Kyra, unfortunately, the only way he's going to be able to see if he can be released by appearing before his judge, Judge Bailey, next week. So at this time, nothing to add by the defense, Judge.
Okay. All right, in light of that, the bond will remain in place, and he'll be seeing his division judge next week. Thank you. Shekinah Dickerson.
All right, Your Honor.
Thank you.
You're welcome.
Good afternoon, Ms. Dickerson.
Good afternoon.
Ms. Dickerson, you're before the court this afternoon on 4 charges. Count 1 is for driving with a suspended license. Count 2, failure to register a motor vehicle. Count 3 is a felony out-of-state hold. That is out of the state of Kansas with a no bond hold. And count 4 is failure to provide proof of insurance. I find probable cause, and I will hear from the parties.
Your Honor, based on the out-of-state hold, I'm not requesting anything.
Okay, Mr. Miller?
Judge, based on the out-of-state hold, I will defer to the court.
Okay, all right, then I'm gonna leave the standard bond in place on count 1 in light of that no bond hold. All right, thank you, Ms. Dickerson.
Could you explain what that means? Because I've never been through this process and I don't know what you just said to me.
Ms. Dickerson, that means that you have a $100 bond on your driving with a suspended license count. You'll have to address that matter before your division judge. There's also the out-of-state hold, which means that you'll be seeing the extradition judge sometime next week to discuss how that's going to be handled.
Okay, so do I bond out now for the $100?
Well, the thing is that even if you were to post the $100, you're still not going to be released from custody because you have the out-of-state hold.
I understand that, so don't worry about doing the bond for the $100, or should I do that?
Well, what I would advise you of at this time is, since I, as the judge, can't give you any legal advice, you can speak with your attorneys. You can speak with someone from the public defender's office to get some advice on how best to handle that. And in the meantime, just so that you understand, because you do have the no bond hold, this out-of-state hold, you're not going to be released until that issue is addressed, okay? So,
Okay, and by you mean address like them coming to get me, or?
yeah, so you would go, we have an extradition judge here in Broward County. You will likely be seeing her sometime next week, so you can discuss how that's going to be addressed.
Okay,
Okay? All right, good luck to you, ma'am.
thank you.
Next will be Adriana Habash.
Your Honor, I was advised that she bonded out.
All right, thank you. For the
welcome.
record, I find probable cause. Next will be Victor Fleming.
He's approaching, Judge. He's here at Maine.
Thank you. Good afternoon, Mr. Fleming. Mr. Fleming, you're before the court this afternoon on 1 charge. This is an out-of-state felony hold from the state of Texas. I find probable cause, and Mr. Fleming, this has a no bond hold on it, which means you'll be going before the extradition judge next week to address how that matter is going to be handled. Good luck to you, sir. Joseph Williams.
Mr. Williams is the main judge.
Mr. Joseph Williams is here. Come on up, sir.
And the state attorney has agreed to make an offer in this case if Mr. Williams is interested in resolving, and the court is also
Judge,
interested.
I did speak to Mr. Williams. He is interested in resolving this matter. Let me let him know what the state offered.
Well, let me first see him to speak to him before we go through that. Good afternoon, Mr. Williams.
Hi.
Mr. Williams, you're before the court this afternoon on 4 charges. Count 1 is second-degree petty theft, second offense. 2 is for obstruction. 3 is for trespassing or failing to leave property upon order by owner. And 4 is for inhaling or ingesting harmful chemicals or dangerous drugs. I find probable cause for these charges, and I will hear from the state at this time.
Your Honor, this offer from the state would be adjudication, time served on counts 1 through 3, withholding court cost on 4. And no return to this Walgreens.
Okay.
Judge, he wishes to accept the state's offer.
All right. Mr. Williams, do you understand the state's offer to you on these counts?
Yes.
Do you understand there's going to be a no return order to the location of incident, which is the Walgreens?
Yes.
That means that you're not going to be allowed to return there. Do you understand that?
Yes.
Mr. Linder, does he have any priors?
He does, Your Honor. 2015 felony criminal use of personal identification information and grand theft. I could check to see if there are other priors. Frankly, I'm offering the withhold on the chemical ingesting chemical count because frankly, I don't know if that could have a negative effect on his driving privileges, and in the possibility could, I don't want to put him in that position.
I'm a little bit concerned with some of the allegations that are included in the probable cause affidavit. Mr. Williams, you're very young to be coming before the court on these types of issues. You know, I hope that if there is some sort of an underlying issue there, that you're able to get some help with regard to that. You know, I'm not going to comment on it any further. If you want to resolve the case today in light of the fact that the state's made an offer and Mr. Romero's discussed that with you, then I'm willing to go through the plea colloquy with you. And if I'm satisfied with your answers to my questions, then I'll accept the plea. But I do that just with the comment that I hope that if there is an underlying issue there, that you would, you know, try to address that at a later date. So,
Sure. Let me just explain that to him.
thank you.
Judge, he's ready to go forward.
Okay. All right, Mr. Williams, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand everything that we have discussed here today?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Correct.
Do you understand that?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Okay. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Can you repeat that?
Yes. Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Oh, yes, I'm an American.
Okay. All right. And Mr. Williams, what plea do you wish to enter? Guilty or no contest?
No contest.
All right. I accept your plea and find that it is freely and voluntarily given. Your sentence as to counts 1 through 3 will be an adjudication, time served, with a no return order. Your sentence as to count 4 will be a withhold of adjudication plus court costs. And once again, as I stated to you earlier, the no return order means you are not to return to the Walgreens that this allegedly occurred at. Do you understand that, sir?
Yes, Your Honor.
Thank you. Good luck to you, Mr. Williams.
Thank you, Your Honor.
Thank you. Next is going to be Justin Swain.
He's here, Judge.
Thank you. Good afternoon, Mr. Swain.
Yeah, good morning.
Mr. Swain, you're before the court this afternoon on 2 misdemeanor capiases. These relate to charges for criminal mischief and loitering and prowling. I find probable cause, and I'll hear from the parties.
Judge, considering as a court date on Monday, nothing to add.
All right. In light of that, I will leave it as is. I'm showing these are no bond holds set by his division judge.
Count 1, right, Judge?
I'm showing no bond on both of them. Is that
Oh, yeah,
correct?
never mind, I see that now.
Okay. All right. So, Mr. Swain, you'll see your division judge on Monday morning. Randall McCollum.
Judge,
Broward, I believe.
those are all MO cases, Judge.
Do we have?
I explained to him that we might have an attorney this afternoon, we might not, but that,
Okay, you know what I'll do? I'm going to place Mr. McCollum's case on recall so that we can see if we have the city attorney coming for this afternoon session.
Can I resolve this today, ma'am?
Mr. McCollum, I'm going to wait for the city attorney to get here so I can find out if you'll be able to resolve it. I'm going to call you back up in a few minutes.
he's at North Broward, by the way.
I understand.
Okay.
Okay, next will be Jocelyn 1.
Bonded, Judge?
All right, for the record, I find probable cause. Walter Smith,
North Broward?
North Broward, Your Honor.
thank you.
And Judge, I spoke with Mr. Smith earlier today. He is interested in resolving this case if the court is so inclined.
All right, good afternoon, Mr. Smith. For the record, you're before the court on a misdemeanor capias. This relates to a charge for trespassing. Does the state have an offer?
Yes, Judge, the documented offer from the assigned ASA is a withhold, court cost, no return to 901 North Federal Highway in Hollywood.
All right, for the record, I find probable cause. Do you have information to see whether that's a business or is it a residence?
I'll try.
What's that address?
I got it.
I just want to make sure
Yeah.
that he knows.
Yeah, of course.
All right, Mr. Smith, do you want to resolve your case today?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down now. And do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
No, ma'am.
Okay. Do you understand that you have the right to trial, but you're waiving that right by taking a plea today.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
Yes, ma'am.
Is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea will subject you to deportation or other immigration changes?
Yes, ma'am.
And Mr. Smith, what plea do you wish to enter, guilty or no contest?
No contest.
Okay, I accept your plea and find that it is freely and voluntarily given. Your sentence as to this charge will be a withhold of adjudication plus court costs. There will also be a no return order. And were we able to confirm what that location is?
Yes, it's a CVS.
Okay, so Mr. Smith, the no return order means that you are not to return to the CVS that's at issue in this case. Do you understand that?
Yes, ma'am.
Okay. All right. Good luck to you, sir. Gene Semelian.
Judge, defense waives for reading of the charges, asks the convenience bond be kept in place.
Okay. Is he present?
He
He's
said
your
the main.
judge.
Okay. All right. Good afternoon, Mr. Semelian.
Good afternoon, ma'am.
Okay. For the record, I find probable cause as to the charges, and in light of what I've been told, the standard bond will remain in place on count 1. Mr. Semelian will be seeing his division judge on Monday to address the VOPs. Ryan Woods Malley.
Medical room.
Thank you.
Mr. O'Neill, come on up.
Christian O'Neill.
He's approaching Judge
I'm
Maine.
sorry.
Can we put him on a brief recall? His bondsman just stepped outside for a moment.
Okay.
Oh,
All
no
right.
problem.
I'll call him back up in a moment. Elmeen Shabazz.
North Broward, I believe.
Thank you.
Shabazz is a medical reset, Your Honor.
Okay. Thank you, Deputy. Yes.
And
You're welcome.
Yes, Mr. Linder.
it's, well, Dale, it's up to you. This is an ad charge, not in custody. He came before it came before Judge Carlton yesterday on another felony theft, and the bond was kept at $750. I don't know.
No objection to the bond is set.
Okay. All right. Then I'll make a probable cause finding, and I'll leave the bond in place on this ad charge, so we won't need to reset Mr. Shabazz. All right. I'm sorry. Desmond Green.
He's here at Maine. He declined to serve as a public defender. My understanding is he advised me he has private counsel. He actually was in front of Judge Coleman this morning. His private counsel wasn't there present, so I believe his case was reset till Tuesday. So on Tuesday, his private attorney will be there. So I'm just giving you the heads up there.
Your Honor, this is really the least of it. Mr. Green has DUI manslaughter charges. I think there are multiple bonds. There might be some no bond holds. So I'm just asking the court keep this bond in place.
Okay, I do see, Mr. Green, good afternoon. I do see, I'm good. So I have you here on some ad charges this afternoon. Most of these have no bond holds, so just for the record, I have, counts 17 through 20 are felony violations of pretrial. Those have no bond holds, and then count 21 is a charge for driving with a suspended license, third or subsequent offense. That has a $750 bond on it. In light of what's going on here, I'm going to find probable cause, and I'll leave the bond in place on the suspended, on the DWLS, since he has the no bond holds. So, Mr. Green, you will see your division judge next week, as we talked about, okay? Good luck.
Okay, so
Your Honor, we can, if it pleases the court, we can recall Mr. O'Neill's case.
Okay.
And Judge, Mr. O'Neill's father and his bondsman are present.
Thank you.
Mr.
I think we have an agreed bond amount and release conditions. If it's
Okay. All right, let's bring Mr. O'Neill back up, please.
he's approaching Judge.
All right. His father and his bondsman are present. In court this afternoon. Good afternoon, Mr. O'Neill.
Good afternoon.
Good afternoon, Your
Good
Honor.
afternoon. All right. Mr. O'Neill, Christian O'Neill, for the record, you're before the court this afternoon on 11
I'm sorry.
charges? Yes.
I just want to also advise the court, because I realized on your findings, it may say armed trafficking for a
Yes,
couple of counts.
it does.
It should not be armed trafficking, Your Honor.
It's just gonna be trafficking.
Yeah, I would direct the court's attention to the booking sheet and also the probable cause affidavit. I don't know how it ended up armed trafficking on the docket, but.
Yeah, I'm not sure why that's on there.
And I also spoke with Detective McKinney, who authored the probable cause affidavit from the Coconut Creek Police Department.
Yes.
It was not his intention to charge him with any armed trafficking counts.
So then on counts 2 and 3, those are the only 2 counts that show as armed trafficking. I'm just going to strike armed from the finding sheet. All right. Are there any other corrections before I read the charges? Okay. All right. Mr. O'Neill, you're before the court on 11 charges. Count 1 is for use or display of a firearm during a felony. Count 2, trafficking methamphetamine, 200 grams or more. 3, trafficking cocaine, 28 less than 200 grams. 4, trafficking phenethylamines, 10 less than 200 grams. Count 5, possession with intent to sell, manufacture, or deliver oxycodone. 6, possession with intent to sell, manufacture, deliver alprazolam. 7, possession with intent to sell, manufacture, deliver cannabis. 8, possession with intent to sell, manufacture, deliver THC. 9, possession of cannabis over 20 grams. 10, possession of LSD. 11 is possession of a forged driver's license or ID. I find probable cause for the charges, and I'm told that the parties have an agreement, so I will hear that at
Yes,
this
Your
time.
Honor. And I've spoken with Mr. Miller and Mr. Durkee, Your Honor. I've also as I mentioned earlier, I've also spoken with Detective McKinney.
Yes.
We're going to be agreeing to a total bond of $100,000. And in a moment, Your Honor, I'll
By the breakdown.
thank you. Pre-trial release with a GPS monitor level 2 as well. The breakdown will be a $10,000 bond on count 1, $50,000 bond on count 2, a $15,000 bond on count 3, and a $25,000 bond on count 4. Counts 5 through 11 will be ROR.
Any other release conditions that have been agreed to?
Your Honor, those are the only conditions we're seeking.
Okay. I'm going to impose my own condition of random testing based on the circumstances.
Understood.
All right. So, Mr. O'Neill, per agreement of the parties, I'm going to accept the agreement that's been reached between everyone. I'm just going to repeat that agreement again so that it's on the record and clear to everyone. Bond on count 1 will be set at $10,000. Bond on count 2 will be set at $50,000. Bond on count 3 will be set at $15,000. Bond on count 4 will be set at $25,000. Bond on counts 5 through 11 will be RORs. If Mr. O'Neill does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. Mr. O'Neill, as a condition of your release, you will also be subjected to random testing. That means no alcohol, no intoxicants. Do you understand that, sir?
Yes, Your Honor, that's not a problem at all.
All
Judge,
right.
may I have 1 moment to speak with my colleague?
Go ahead.
We're ready to proceed, Judge.
Judge, at the risk of gilding the lily, I'm asking for a 30-day waiver for THC.
Yeah, my understanding is, Latifi, that's standard, isn't it? Oh, really? It's fine. My understanding is that,
All right. In other words, he could potentially fail on his first test if we don't give him the waiver.
No, yeah, I get the reason for the waiver.
Yes. All right. I will approve the 30-day waiver for THC only.
Thank you, Your Honor.
You're very welcome. All right.
Thank you, Your Honor.
You're
Thanks a
welcome,
lot.
Mr.
Thank you so
O'Neill.
much.
Good luck with everything.
Thank you, sir. Thank you. Thanks.
Address it now. All right. Do we know if we have a city attorney coming this afternoon? Okay. All right. Thank you. Let me know as soon as we know on that one. I'll leave that, we've only had one so far. I'm just gonna leave it to the side for now. Until we hear back. Okay, for the time being, I'm gonna go over to our hearing docket. I'll start with the misdemeanor cases. The first one will be Michael Norton.
He's here, present, Judge in main.
Thank you. This is the second look. All right, good afternoon, Mr. Norton.
Good morning, Your Honor.
Okay, so Mr. Norton's here on a second look. Tell me what's going on in his case.
Judge, I believe I came before you earlier this week and I asked for standard pretrial.
Yeah.
I am assuming, and I believe what's imposed is with the GPS monitor. He was going to be residing with his brother, I believe Emilio. After speaking with his brother, unfortunately, because he has his kids, children, they have no space. So unfortunately, he's in a position where he can't go to those premises. So what I'm going to ask you at this time is, he spoke to his brother. His brother would be willing to post a monetary bond for him. I believe initially the grand theft auto, I believe, was at $1,000. So I'm asking you now to go ahead and reinstate the bond amount.
And Judge, Mr. Norton has a case on the felony docket as well.
I do, I just noticed that. All right, so Mr. Romero, one second, I just want to clarify. Mr. Romero, you're asking me just to reinstate the bond amount on count one?
Yes, Judge, I believe his brother is going to maybe be able to come up with $100 with the bondsman. To be perfectly candid, I think maybe the misdemeanors also had a bond attached to
They
them, where
do.
the felony driving it did.
They do, that's why I was
But
asking.
I would ask you, Judge, to consider ROR the others and $1,000 on grand theft auto. But at the very least, if your honor's not comfortable and you want to leave it back at the same position he was, then obviously that's going to be more feasible for his brother maybe to try and work some more and try and get money to get together for the bond. But I'm asking $1,000 in ROR the rest.
Your Honor, I'm asking if the defense is asking that the bonds be reinstated, then all the bonds be reinstated.
All right, based on the circumstances, I'll reinstate all of the bonds to their original standing. I just want to make sure I have it right because they're a little bit scratched out on my finding sheet.
It's
so I-
1,000 on one,
Okay,
100 on two, 750 on three, and the capias was at $100 also.
okay, that's on 7. It's 100.
Yes, Judge.
Okay. All right. That's fine. My order that I previously entered that Mr. Norton not be driving is gonna remain. My feed just went out.
He just almost got it in.
We're so close. All right,
It's like one
I'm
more
gonna
word.
we'll go off the record until we get our
that?
feedback.
Yeah, it's just going like.
Carol, can you hear me?
Yes, Judge.
Okay,
Yes, yes,
all right, good. I'm gonna try to get this done before our feed goes out. All right, so I'm reinstating the bond amounts to what they originally were set at, the standard bonds. I also had ordered at first appearance that there be no driving. So Mr. Norton, that is going to remain in effect. Do you understand that, sir?
Yes, ma'am.
Okay, all right, thank you. Okay. All right, next on my list here is Thomas Moran. Okay, all right, I'll put him on a recall. We'll come back to him. Let's go over to the felony docket. Next will be Keyshawn Demps.
This is with the misdemeanor,
He's in court?
Jazz? I think we
Okay.
can address it, Your Honor.
Okay,
What I'm being advised, what happened was, Mr. Demps had two separate cases.
yes.
He had a, one moment. Thank God. He had a grand theft auto with a $1,000 bond, and then this case. What I'm being advised is on the grand theft auto, he was ROR'd and placed on pretrial with the GPS. Okay. On this case, what happened was he was on pretrial on this case. When he picked up the new grand theft auto, the judge, I believe at his first appearance, revoked his pretrial and got a no bond on the possession of cocaine and a $5,000 bond on the theft. Since then, the state has no info of the cocaine and downfiled the petty theft to a misdemeanor.
Okay,
So I have considering that he's going to be on a GPS monitor on a separate felony case, I have no objection to just RORing him on the new. Let me ask Jazz, is he still being held on the 5,000 on the felony? But do you guys know that? Have you guys gotten the paperwork on the change of charge yet? So why is it still showing as a felony in the system? So do we need an order? Okay. So last question. Do you guys need an order with the felony case number and the misdemeanor case number? Okay. Then, Dale, we're gonna need on Keyshawn Demps, if you want to prepare an order under his new misdemeanor case number, RORing him on the theft that we filed. We did not file the cocaine. On his separate grand theft auto, he was given pretrial GPS today by his judge. It's okay. He had a grand theft auto, and then he had this case that we're here on. The grand theft auto. This case, we declined the cocaine. We declined the cocaine, filed a petty theft. It's 20989 MM10A, and the only charge is theft, petty theft. Yeah, and I'm fine with just RORing.
y'all are on that, thank you.
Sorry about that.
That's all right, that's all right. I just wanna make sure.
And we're
we-
ready for Mr. Moran when the court is.
Okay, so we will go back to Mr. Moran's case now. Which facility is he at?
T. Judge.
All right, good afternoon, Mr. Moran.
How you doing, Mary?
I'm well, so Mr. Moran is here on a second look. I believe his bond is currently set at $1,000.
Yes, Judge. And I
Okay.
spoke with Mr. Moran. He cannot afford to post that bond
Okay,
at this time. He is a lifetime resident of South Florida. He's been at the same address for the past 30 years. He does live with his parents. He does have a job. He works at a pizza place as a cook. He's been there for, I think, 3 years.
Yes, I have,
He also supports 3 children and an ex-wife, and so his funds are limited. If the court would consider pretrial release, he would accept that, and the alternative, if the court could lower the bond to 250, he might be able to post that.
And Mr. Moran, I think he appeared before you yesterday, maybe? And you were advised by Ms. Hardy, he's shown over time, he's just not a good candidate for pretrial. He's been put on pretrial, my understanding, more than one occasion, and he always...
It was a long time ago, Your Honor.
Wasn't it a year ago or something?
Let me just confirm with pretrial. (2018).
Your Honor, Mr. Moran's he's come through this division a lot of times. In this case, he got stopped by Publix employees because he was trying to steal an electric cart. When they stopped him, and then they said, just leave, he refused to leave. He got into an altercation with an employee and spit in the employee's face.
When was this? I was outside the store. I never even went in the store.
Moran, please don't talk about the facts of your case. Everything you say is being recorded.
And I'm showing, let's see, one. And what I've seen when he gets arrested, it's usually one of two situations. There's either a capias or a failure to appear, or a court-ordered hold because he's out on a case and picks up a new case.
Ma'am,
Yes,
It
Mr.
was-
Moran.
Ma'am.
Hold on one second, Mr. Moran. I just want to tell you, I need you to heed the advice of your attorney. Please don't say anything about the facts of the case. We're just addressing bond and release conditions right now, okay? Do you understand that?
yes, ma'am, but I'm gonna tell you what it was. It was a wheelchair thing, a motorized wheelchair thing. All I was doing was backing up and moving it forward. I wasn't trying to steal. How was I gonna steal it?
Okay,
Well,
well,
it's
I
drug-
think, well, you haven't been charged with theft. This is a battery issue that's going to the allegation of spitting in someone's face, but I don't want you to comment on that right now, okay?
Yes, ma'am. Ma'am, I need support, my kids, please. I'll show up to court. I always have.
All right, hold on, Mr. Moran. Give me a moment to make a decision.
Yeah, there may be other issues, Your Honor. I'm showing a 2011 case with burglary with assault and strong arm robbery. The case went on for 5 years, from 2011 to 2018. Because of competency issues, he was revoked on pretrial multiple times during the pendency of the case and placed back on pretrial. Then a warrant gets signed for failure to comply with pretrial, and then back and forth and back and forth.
I was finishing programs. Finish them every 90 days.
All right, based on the history that's been presented, I'm not sure if there's other issues going on that I'm just not aware of at this time. So based on the history with the failures to appear and everything, I'm not comfortable with releasing Mr. Moran to pretrial supervision at this time.
Court considered lowering the bond to 250 with...
Well, I would consider lowering it to 500 and then placing him on standard pretrial if he posts that monetary bond. If that's something that he's interested in.
Judge, do we have any other cases? Put this on brief recall so I can speak with him.
We can put it on a recall. We have other cases.
Thanks.
Okay. All right, Mr. Moran, your attorney's going to call you and speak to you, and then I'll bring you back up. All right, let's go over to Dean Smith.
No problem, John.
Thank you. This is a 30-day motion.
It is, Your Honor, and he's being held locally. 4 counts of burglary conveyance, 1 count of larceny of a credit card.
Yes.
We have now filed an information, so he's entitled to an ROR on these charges.
Yes.
The only other condition I'd ask to remain in place is there was an order of no return to 11522 Northwest Fourth Manor in Coral Springs. Mr. Smith just needs to be aware that even if he's ROR'd on these counts, he has a total bond of $9,000 on 2 out-of-county holds out of Palm Beach.
Okay, so will Palm Beach come pick him up on those? Okay. Okay, so Mr. Smith, a couple things that you need to understand, okay? So first off, the state has told me that they have not yet formally filed these charges, which means that you are entitled to an ROR for these charges, okay? With that being said, you still have, as the state attorney was just saying, you still have a total of $9,000 for the out-of-county hold out of Palm Beach, which means that though I'm going to ROR you on these charges, that doesn't mean that you're going to be released from custody. It means that the jail will notify Palm Beach that you're ready to be picked up. Do you understand that?
Yeah.
Okay, the other thing is, though you're going to be ROR'd on these charges, it does not mean that it's the end of the case, which means that it'll be your responsibility to keep in contact with your attorneys in the clerk's office regarding any future court dates that you have to be present for. So if you're in custody in Palm Beach County and a court date happens in Broward and you're not present, then a capias gets issued. So you have to make sure that you keep up with your attorneys to monitor those court dates. Do you understand that?
Yeah.
Okay. There's also going to be a no return order, which I believe is already put in place, but I'm going to repeat it again. There's a no return order, which means that you are not to return to the location of incident in this case. Do you understand that?
Yeah.
All right. So I'll grant the ROR on these charges. Okay. All right. Thank you, Mr. Smith. Good luck to you.
Judge, I spoke with Mr. Moore, and he is going to decline the court's offer at this time.
Okay. Where was he at Conti?
Conti, yeah.
Thank you. Okay. All right. So then, what I'm gonna do in Mr. Morin's case then, if he doesn't want to do that, is I will leave the bond in place as it is, and if he's unable to post it, then his division judge will be able to address that.
Thank you, Your Honor.
Okay. All right. Good luck, Mr. Morin.
Making a big mistake, Judge. You have a good day.
Thank you.
You too.
Okay. Then I have on our felony docket, that was the other Norton case. Okay, so I think we only have one case left, which is the municipal ordinance case. Okay. All right, so I will take Randall McCollum. Which facility is he at?
That's right, Your Honor.
Thank you. Good afternoon, Mr. McCollum. Mr. McCollum, you're before the court this afternoon on a total of 4 charges. The first 3 are municipal ordinance violations. Those relate to, count 1 is for open container, 2 is disorderly intoxication, 3 is resisting arrest without violence. Count 4 is a misdemeanor capias. That's also a municipal ordinance violation for an alcoholic beverage violation.
Judge, may I speak as friend of the court?
Yes, I find probable cause, and yes, Mr. Miller, what would you like to say?
And this is just throwing this out there, but if the prosecuting agency does not appear, the court does have the ability to throw these out.
I appreciate that point, but I'm not gonna throw these out at this time, based on what I'm seeing. And we do have the capias that's been issued by the judge anyway.
Ma'am, is there any way I could resolve this today?
Let me just see here, Mr. McCollum, one moment.
I'd like to put myself in the bark because I'm just drinking my full self to death.
Well, I would like to see you get help for that rather than do that. It seems that might be a better alternative.
Is there any way that you can get me into bark?
I'm just looking to see right now if these are all, can someone check for me the capias? Is that a Fort Lauderdale MO? Because I want to, McCollum, I want to see if he can go to community court.
I'll check. Your Honor, my understanding while I'm looking
Yes.
is even if it's not a Fort Lauderdale case,
Yes.
like let's say the case gets resolved, if he goes there, they'll offer assistance, even if he doesn't have an open case. That's what I've
Well,
been
that I
advised.
do, yes, that I do know.
I think I spelled it. What's his first name?
Randall.
Randall. Okay. I'm gonna go. Yeah. No. I appreciate it. I just. The judge wants to know what jurisdiction his case is in. What city?
The Capias. Capias is Fort Lauderdale? Okay. So, Mr. McCollum, if you are interested in getting some help, then what I could do is, you have the four charges here are all Fort Lauderdale municipal ordinance cases. So, I could transfer your case to community court, which is held every Wednesday at the Fort Lauderdale City Hall. Yes, Mr. Linder?
I'm sorry to interrupt.
That's all right.
Checking the case, and honestly, I also want to let you know, Mr. McCollum is scheduled for. He's scheduled for a status before Judge Lerner Wren on Monday morning.
On Monday?
In our mental health court, yes.
On a separate case?
The Capias.
On the Capias.
But what you could do, and I could text her JA if you just want to have everything go. So his situation, so it's not dealt with, piecemeal.
Okay. Well then that might be a better situation. So Mr. McCollum, what I'm being told is that your case that you have the outstanding Capias for is in Judge Lerner Wren's division. And she has a lot of resources that could help you, since that's what you're asking for. So you've already got a hearing scheduled with her on Monday, as of right now. So
Is today Wednesday?
No, today's Friday. So it would just be in a couple days. So what I can do is I can put the other three new charges into her division at the same time, so you can deal with all of them on Monday before her, and she would be able to give you the resources that you need to get the help that you're asking for. Does that sound good?
Yes, ma'am. Will I be released today?
You won't be released today, but you would be seeing her first thing on Monday morning.
So that means I'll have to stay in jail all weekend?
That's what that means, Mr. McCollum. But she would be seeing you first thing Monday morning, and she's got a lot of resources that she's got in her division that would be able to help you. So I think it would probably be your best bet right now.
Can I just go ahead and just go on and resolve this today?
Well, I'm not going to resolve the case that she has anyway. She's got an outstanding Capias for you. So since I'm not going to resolve that one, I don't think that it would be in your best interest to resolve the other three that are pending right now. I'd rather just keep them all together, okay? So what I'll do is I'll sign an order transferring the other three charges to her division so she can deal with all of them together.
Yes, and I literally just texted her judicial assistant letting her know there's an additional case that doesn't have a case number in Odyssey yet, from what I can tell.
Yes.
But it does exist, and he's
Okay.
set already on the other case.
Okay,
for
great.
Monday.
All right, so Mr. McCollum, you're going to be able to address everything on Monday morning, okay? Good luck, sir.
Thank you, ma'am.
It's mental health court, Lerner Wren. All right, so I believe that brings us to the end of our afternoon docket. So I hope everyone has a good weekend, and I'll see you all back here on Monday.